So, as Ian says, I'm going to talk about two things in the time that I've got allotted. The title of my talk is AI Licensing and Contracts. So, on the licensing side of things, I'm going to be talking about a little bit about the copyright that applies to AI. I'm not going to talk about patents for two reasons. First of all, I know very little about patents. And secondly, I went to an excellent talk in Dublin last week about AI and patents, and I was hoping to steal a lot of the content of that truly superb talk and recycle it here. Unfortunately, that excellent talk was actually given by Burkhardt, so I thought I couldn't really get away with that. But unfortunately, you have been shortchanged. If you can persuade him to disgorge that particular talk, which wasn't the same as the talk that he gave earlier, I can tell you it really is very, very interesting. So, on the licensing side, as I say, I'm just going to be talking about copyright. On the contracting side, I was going to spring the surprise that it's an old approach to a new problem, but I think we discussed earlier what that is, so I'm importing some aspects of Roman law into the concept of AI contracting. So, talking about copyright and AI. So, what we're particularly interested in here is if you have a work that's generated by an AI, is that something that attracts copyright protection? And from a European law perspective, the InfoPact decision gives us this sort of common thread through all sorts of copyright work, which is really there has to be some form of the author's own intellectual creation for the work to be regarded as being protected by copyright. I'll talk about that a little bit more in a second, but clearly that's potentially problematic as far as AI is concerned. And a third question that I'd like people to think about is the fundamental point of what are intellectual property rights for, in particular, what is copyright for? And the answer is sort of probably best found in the American formulation, in that it is intended to give a limited monopoly, as a monopoly from a limited period of time to a creator in order to incentivize creators to create more work. And that's really what it's for. And it's very easy as a lawyer to fall into the trap that intellectual property rights are good. We've spent a lot of time trying to protect intellectual property rights for our clients, and that tends to then mean that the corollary of that is that more intellectual property rights are good. So fundamental question is here: do we actually need to extend intellectual property to cover computer-generated works or not? Here is there's an EU study that's been referred to before, 2016, and the fundamental question that it posed was: can an autonomous robot be deemed the author of an intellectual work, entitling it to copyright protection? There's an excellent paper by Margareta Berler, which it's actually quite difficult to track down the author of this paper. The paper is quite readily available, but because it was submitted as an anonymous master's thesis, there is no author detail on it at all. So I had to do a little bit of digging around to find out who the author was. And there's a link there with the author's name on it. This is a really interesting paper. It's very accessible, very easy to read, and it's got quite a lot of history behind it as well. But she considers that there are 4 modes in which an AI can produce a copyright work. So there's co-production. And by co-production, we basically mean that the AI is purely a tool. You are using this AI at a very basic level. It could be some sort of mechanism, for example, within Microsoft Word that helps to correct your grammar or to correct your spelling, something like that. And I don't think sort of any of us would have a particular difficulty in saying, no, in those circumstances, the author is the human who wrote the underlying document, for example. Then there is human generation of pre-generated works. So this could be something like where you're looking at a system that produces stochastic music, random music. Obviously, most of the music that this system generates is going to be pretty dreadful. So what a human is going to do is to try to tweak some of the aspects of the algorithm and then ultimately select the output to select those particular pieces of output that are most musical or are the most interesting. And there's absolute absolutely some forms of human interaction going on there as well. Then there's a brute force method, and that is where you just look at a particular problem space. So, for example, one of the examples that I think Burkhardt came out with in his talk in Dublin was a Viennese artist who had come up with the idea of using AI to help assemble all of the possible combinations of what I think was 100-word, 400-word paragraphs. The idea that this would somehow hack copyright, in that it would be possible to register all of these possible combinations at the US Copyright Office, and therefore you would end up with a monopoly on all possible 400-word sentences. Now, anyone who knows about copyright, which is basically everyone in this room, knows that there are serious legal problems with that. Although, before I heard about this, I did come up with a sort of similar idea over a couple of pints with a friend of mine who is an artist, and this was around the time that there was a lot of controversy over the Happy Birthday, the song Happy Birthday, and the fact that still seemed to be subject to copyright. So we tried to come up with a sort of very narrow problem space in which we could get something to brute force create all of the possible small musical phrases, one of which would be Happy Birthday, and then basically license that to people who wanted to use Happy Birthday in their films, whatever, rather than having to go to Warner Brothers or whoever it was asserting copyright at the time. As I say, this was one of those ideas that seemed like a great idea after a couple of pints. The next morning we had other things to think about. But the one that's of most interest really is this concept of independent machine creation and selection. And this is really where you configure an AI to go off and do something, and what it produces, you don't really know what it's going to produce. It is something that has much more of the nature and the feel of human creativity than the other three modes. Does anyone recognise this? Any idea who the artist is? Or more to the point, you'll have guessed who the artist is. Anyone got any idea who they think the artist should have been? Okay, this is called The Last Rembrandt. It won't surprise you at all to realise that it is not a Rembrandt, but it was actually created as part of a collaboration between Microsoft, ING Bank, I think, and a sort of number of other companies. And the idea was to use an artificial intelligence algorithm to ingest as many Rembrandts as they were able to feed into it, and then produce something that looked authentically Rembrandt-esque. This is one of those things where that there is a website dedicated to this, but it's far too clever. It's actually very difficult to get a screenshot, I think probably for sort of deliberate reasons, so it took me quite a long while to get this. I'm comfortable that there's no copyright in this particular work, but don't take that as my legal advice. But it was clearly generated by a computer. One interesting thing is it appears to have been produced on a 3D printer. So I think if you actually look at the painting as produced, it also has the sort of the textures of a real painting as well. So I'd be very intrigued to actually sort of have a look at it in the flesh. But that's an example of really one of the ways in which artificial intelligence can be used to create completely original artworks. So that really sort of summarises the position in the European Union in general. But in the United Kingdom, the situation is slightly different, and indeed, in a relatively small number of other jurisdictions. Ireland is one of those jurisdictions. I think India might be, New Zealand. But there aren't too many of these other jurisdictions that actually have a specific provision in the copyright legislation to deal with computer-generated works. So there are two interacting sections. The first one says that in the case of one of these works, the author is to be taken by the person by whom the arrangements necessary for the creation of the work are undertaken. So the person who configures the AI, for example, is what it's intended to be. And then section 173 contains a definition of what computer-generated means. So it means that basically, if there is no human author, then the default is that section 9.3 applies, and it's the person who made the arrangements. And there's very little guidance in the case law as to what that actually means. However, we do have one case called Nova Productions and Mazuma. So Nova Productions is a company that produces gambling games, these sort of things that you find in betting shops these days, and there was a game called Pocket Money, which was based on a game of pool, and Mazuma produced a very similar game, and this sort of very extensive litigation covered this. But one small part of the litigation had quite an interesting comment by the judge, Mr. Justice Kitchen. He said the arrangements necessary for the creation of the work were undertaken by Mr. Jones because he wrote the relevant computer program. He, therefore, is deemed to be the author by virtue of section 9.3. So under English law, we have this situation where this guy who wrote the program becomes the person who made the arrangements, and therefore he becomes the author. And then the case goes on to various other things about the relationship of that person with the company, etc. But that needn't bother us at the moment. But that leads to some slightly peculiar consequences. So if I was to get hold of a copy of the Pocket Money game, and I was to sort of plug it in 150 years' time and run it. So here is this game busy producing copyright works on its screen, the artworks that it produces. Now, this is a long time after the death of Mr. Jones, so the normal copyright period being 70 years after the death of the author. Chances are that any copyright that he normally would have expired by then anyway. But does that mean that all of a sudden a brand new copyright is created? Because section 12, subsection 7 of the Copyright Act says that if the work is computer generated, copyright expires at the end of the period of 50 years from the end of the year in which the work was made. Now, if the work is made 150 years hence, does that mean that there's, in effect, there's another 50 years from that date? I don't know. This is just an unintended consequence of this piece of legislation. From a sort of practitioner's perspective, if this is something that you're concerned about and you still think you're going to be around to be potentially sued 150 years down the line, you might want to think about putting in any contract, this is where the contracting bit comes in, for any works which involve the creation of AIs which might produce copyright works, something that actually deals with the assignment of any future rights which are created by the author. So the difficulty here is that quite often you get a situation where you've got a contractor who is working for a company, and that contract agreement, there isn't a situation where the contractor's work, the contractor does the copyright in that work, will automatically transfer to the company. So typically in the agreement you'll put an assignment of copyright, and that'll deal with the code that the contractor has written. But it doesn't deal with a situation where the works that arise because you run that code have copyright in them. So that should be something that drafters of contracts should consider. So really, this is, I don't have any particular solution to this. I think it's just sort of interesting observation of unintended consequences of not particularly well thought through legislation, and one particular judgment on this. And in reality it's fairly unlikely to happen, because normally there will be the ability to say that there is a human author in the chain somewhere. It's fairly unusual where you have a situation where the court can determine there is no human author. But it does lead on to quite another interesting thought experiment, which is not entirely unrelated, because a lot of the rest of the consideration of the Mazuma case was the relation between the game that was originally written by Nova Productions and the one that was written by Mazuma itself. And it was acknowledged that there was no actual literal copying between the two. It was really just the ideas and the concepts that were copied. And computer lawyers will be familiar with the concept of a clean room rewrite. And Article 1.2 of the Software Directive makes it clear that it's the ideas and principles underlying a piece of computer software themselves are not protected. It really just is the expression that is protected. And we're not getting so far away from the position now where, especially for simple program, you could have an AI analyze the program and then describe in purely functional ways in which this works. You know, it could have a look at a very simple basic program and say, okay, this program contains an integer which is incremented by 1 in a loop. Every time it goes up, it prints the value of the variable on the screen, and then it finishes when you get to 10. And then it's also not so difficult to understand, to imagine a situation where a similar AI could look at that functional description and then turn it back into a program again. So now we have a sort of computer-to-computer mechanism without any human interaction at all, where you can take, you know, the expression of a computer program, have another computer program turn it into a functional description in the way that you would if you were doing a clean room rewrite, and then have another AI analyze the functional description and turn it back into a program again. So again, I have, you know, no idea what the consequence of that would be, but that is a little bit scary potentially. So how are we doing for time?
Okay, fine.
Yeah, super. Right, so now we're going to wind the clock back a couple of thousand years. I'm going to go through this reasonably quickly because we actually discussed quite a lot of this in earlier sections. But if you are contracting with some form of machine, as I think somebody mentioned, I think it was probably Burkhardt actually mentioned that a lot of this problem is solved by a Coker vending machine. And the law has sort of retrofitted a mechanism onto the way that works to describe what happens from a legal perspective. But you know, clearly, if you put your sort of £2 into a Coke vending machine, you know, only the most pedantic of lawyers, possibly everyone in this room, would actually start thinking that some form of contract has been formed. You know, at the end of the day, £2 goes in, you get your Coke out, and in fact, the vending machine was invented probably about 2,000 years ago. Hero of Alexandria invented a vending machine that you could pop a coin into a little device in a temple, and it provides a pre-measured amount of holy water for you. So, you know, this problem was actually solved, you know, a long time before the Coca-Cola Corporation came along. Then we have the concept of smart contracts, which are neither smart nor contracts. I will say as little as I can about those, but you know, they're basically a way of automating changes of relationships. I don't really think of them as sort of contracts in anything the way that as a lawyer would consider them to be a contract. But basically, what you're doing is you're causing a machine to be a tool that is changing its state, and predetermined relationships between people are affected because of the way the machine's state changes. But what happens if you're trying to contract with an autonomous intelligent agent? So you're looking at something that is, you know, no more than a mere tool. From an external perspective, you know, it may look, if you're an external observer, it may look as though a contract is being formed in actually quite a traditional legal sense. These ideas of offer and acceptance. And I realise that contracting works differently in Scotland, so I won't go into too much detail. But I think, but you know, I'm assuming that the underlying principles are broadly similar. And it may be the case that autonomous intelligent agents, you know, if they're given too much power, may be able to form apparently binding contracts in ways that their human owners didn't anticipate. But you know, there could be something that looks very similar to the idea of a meeting of minds, which is required in English law, at least, in order to be able to externally demonstrate that some form of contract has been formed. So, what is an autonomous intelligent agent? Well, I'm not going to dwell on this. Previous talks have sort of gone into what the definition of autonomy and an agent is. But you know, there is a wide variety of entities, anything through sort of web bots and various software tools. You know, it doesn't necessarily have to be something that looks like a programmed humanoid agents. But what we have analysed, and this is a paper that Michaela MacDonald and I have been working on, is really we've been looking at categorising a number of different sorts of agent. And so first of all, we look at a single target agent, and a single target agent is a software agent which is designed to operate against a single platform. And probably a good example of that is with eBay. You can use something called a sniping application. I don't know if people are familiar with this. So what a sniping application is, it's a separate program, it's a web service, and you subscribe to it, and crucially, you have to tell it your eBay username and password. And so you go onto eBay and decide that you want to buy that particular Grecian urn, and you're prepared to pay up to £300 for it. Now, normally, you would just then put your bid of £300 in. Actually, for people who use eBay, you'll know it's not a bid of £300. Basically, what it does, it bids up in increments up to £300. So there's still a possibility that, if bidding doesn't reach that level, you still get it for £150 or whatever. But for various reasons, some of them psychological, some of them to do with the technology. It's the case that, and you may have, again, have experienced this if you bid for anything on eBay, suddenly there's a sudden flurry of activity just before, just as the auction is about to close. And that's known as sniping. And quite often it's, human individuals will wait until the very last moment and think, aha, if the bid's at 100 and I can put in 105 just before the auction closes, people won't have time to bid me up. Right, so that's the logic behind it. And then the next stage is that somebody thought, right, well, why don't I write a piece of software to do that instead? And it can just automatically...
Exchanges, they use it also, yes?
Yeah.
You give the options and then they, for example, if it's at night or whatever.
Yes, exactly.
In different places in the world. So
yeah, exactly. So there's,
the artificial intelligence.
That's right. Yeah, exactly. So so the decisions that they can make become more and more intelligent. So this is a single target agent. It's something that these automated bid sniping platforms are ones that are very closely allied with eBay. They will only work on eBay. And from a liability perspective, it's fairly straightforward because your eBay terms and conditions say anything that happens under your username is your responsibility. So if this sniping thing goes haywire and suddenly says it's going to pay $1 million for your Grecian urn, which is only worth 150, then tough. You've under the eBay terms and conditions, you'll find that you're liable for it. Then you can have a multi-target agent, which can be something that is programmed to look at a number of different sites, but it has to be carefully programmed so that it works using those each individual sites' sort of quirks and foibles and the different interfaces and so on and so forth. And it could be the case there, for example, that you say, right, I want you to go out to your agent, I want you to go out, have a look at a number of different auction sites to determine which one of these has got sort of, a Grecian urn that falls within my specifications, and then you go and bid on whichever site is going to be the best one, etc. So that's the next level of sophistication. And ultimately, you can get to a situation where you actually have a whole number of entities that agree that they're going to contract with each other on a unified set of terms and conditions, a set of umbrella terms. So, and hand in hand with that would be the case that they also have sort of unified interface as well. And there's a number of markets that work like this, that have a number of players who've all agreed to sign up to a unified set of terms and conditions. They welcome the use of automated technology to broker between them. They provide the technology to do so. And all of the trades that take place within that marketplace are governed by the overriding set of terms and conditions. And so that's what it's called the walled garden, because you have to sign up to the terms and conditions to begin with in order to play, and then once you're playing, you can play within this garden with any of the particular entities that are also operating under the same set of terms and conditions. Engerati and the Swift network are two examples of networks that actually operate under this idea. They have a sort of unified set of terms and conditions. But what if you want to leave the walled garden? What if you want to set up some sort of structure where autonomous agents can contract with each other and contract with third parties? And there's a number of different ways where this has been considered, and this is where the idea of having something like legal personality comes in. But ultimately, the fundamental theory always remains when you say what sort of liability should any of these autonomous agents have, is there is an owner of the agent, and the owner should be strictly liable for whatever that agent does. And for various reasons, this can start to get fairly complicated to figure out who the owner is, where the liability lies. Is it the person that set the program off? If because of a bug the program does something that it shouldn't do, then who is liable? Is it the person who coded it, etc., etc.? So you start to get into sort of fairly complex issues there. So this is where Roman law comes in. Now, in ancient Rome, a lot of the commerce was undertaken using slaves. Clearly, if you are a sort of wealthy person and you have to have some means of making money, you don't necessarily want to run a shop by yourself, since slaves are readily available. Why not get a slave to do it instead? And slaves, from a Roman law perspective, they weren't regarded as people. They were regarded as race, as things. So in the same way as you own a horse, you can own a slave. And in the sort of an analogy of a Coke machine, this was sort of fairly straightforward, because if you were to go down to the market and you saw a market stall there which was manned by a slave, and this slave was selling the equivalent of cans of Coke, and you handed over your sesterces, then you would immediately either get a can of Coke or you wouldn't, and you wouldn't be thinking in terms of a contract being formed. But slaves were gradually given more and more power, and were able to manage businesses, and were able to make more long-term decisions in which these businesses operated. And clearly it was very beneficial for the owners to have the slaves able to do this. But if you were somebody who was transacting with a slave, you would be fairly wary of transacting with them if you knew that, this is the equivalent of a Coke machine. If it all goes horribly wrong, then I can't sue the slave, because the slave is a thing. It's like sort of buying a can of Coke from a dog. So the Romans put in a sort of intermediate mechanism that didn't grant the slave full personality, but gave them a sort of proto-personality from a legal point of view, coupled with limited liability. And this was called the peculium. And it was generally known what a slave's peculium was. And it was typically a sum of money, but it could also be other assets as well, and it could even include other slaves. And in fact, the slaves could also, those sub-slaves could have their own peculiar as well. So you have this sort of complex web of slaves owning other slaves, and each of these assets would have value. And if you contracted in a fairly complicated way with a slave, then that contract would be binding up to the value of the peculiar. So, from the purchaser's perspective, you would know that if the slave was operating within the value of their peculiar, that your contract would be honoured. And from the master's perspective, you would know that sort of the maximum liability that you would be able to have was you'd already allocated to the slave. It was the slave's peculium. And the peculium was sort of regarded as belonging to the slave, and after a sufficient length of service, quite often it was the case where slaves were able to buy their own freedom using their peculium as the funds to do that. So, the metaphor is fairly obvious. I'm not going to labour the point here, but there is definitely a comparison between a slave who is capable of making autonomous decisions and entering into transactions, and an autonomous intelligent agent. And then there's also a parallel between the owner of the slave and the person who set the agent off running in the first place. So the proposal really is to map the Roman peculium onto an autonomous intelligent agent, and to do it in such a way that it first of all protects the person who is setting the agent running in the first place in terms of limited liability, because they know that their liability is limited to the extent of the peculium. But it also reduces friction as far as the transacting person or the other agent is concerned. I mean, you could have sort of agent-to-agent contracts as well as agent-to-person contracts. But in the modern world, it's going to be significantly easier to be able to determine what the value of the peculium is than it was in the Roman world, because this could be held in a database, and for once this is actually sort of fairly valid reason for implementing this in a blockchain. Every time the agent transacts, then the value of its peculium can be reduced until that transaction is successfully completed. So it enables it enables somebody, without knowing anything at all previously about this agent, to determine whether the agent is something that is worth transacting with, whether they're going to be able to fulfill their obligations or not. So we see it as being something that sort of goes one stage further than just being a bundle of assets. Ultimately, if you are the master of a bunch of agents, you're the owner of a bunch of agents, and they're out contracting, and it turns out that those agents have got a pretty good track record, this is the point at which the insurance industry might want to step in and say, okay, well, we can basically grant you an increased peculium through some form of bond or guarantee or something like that for a fee, because we think there's a relatively low risk of this peculium being depleted, and the benefit to you is that obviously your agent can then do more and larger transactions. So what we're doing here is really trying to strike a balance between the risks of transacting with an autonomous intelligent agent, but also encouraging the use of agents. And the economic theory behind this is basically the more agents there are to transact with, then it means that the cost of transactions goes down, and if you're looking at it from a pure arbitrage perspective, it means the ability to get whatever it is you want to purchase is likely to hit the lowest price as well. So the idea is that we have sort of a perfectly free flow of information. So quick plug, this sort of full version of the analysis is going to be produced hopefully in the fairly near future in a book published by the Edinburgh University Press in the Future Law series. I think Katz is one of the editors of that, although he's not the person who I've been dealing with, so yeah. Yeah, exactly. So yeah, I'm sure the book will agree that it is well worth purchasing whenever it comes out. I don't know if you have any more information about that. So that was a very rapid run through sort of two completely orthogonal areas of AI and the law. Thank you very much indeed for listening.